Now, let me give you a description, and then I'm going to show you. The general exception it applies, as we'll see on Friday, to health and environment and so on, and public order and public morals, but it also has a protection for privacy and fraud. It is not something that when a government introduces a law that might breach something related to e-commerce, not just in the annex, but in the schedules and so on. It's not just something that says, oh, okay, that's all right then, right? It's a defense the government has to establish once it has been shown to breach the rules. So the onus, the obligation, is on the government to substantiate the defense. Right? And if you think, let me give you a kind of example, is you have a law on privacy in your country. That law on privacy is the best example to use. Needs regulations or administrative practices to put it into effect. Yeah? So we might have a big general privacy law, and then we have operational rules. So a measure that's adopted to secure compliance with a law, yeah? That's the kind of thing we're talking about. Right? We're talking about a law and then the measures to implement or secure compliance with it. That relate to consumer protection only says for fraud and default on services contracts. Right? It's not the whole range of consumer protections. Yeah? It's just if there's a fraud or if there's a default on a contract. And the operational rules and laws for securing compliance with a law relating to privacy. That involves processing and dissemination of individuals' data and confidentiality, not corporate or commercial data, and not storage of data, not sale of data, not access to data. So it's actually, both those are very limited in their scope. Yeah? But this exception applies to the operational parts of laws and measures relating to fraud or privacy when those laws are not inconsistent with TISA. So basically a law that TISA allows you to do, the exception is saying you can adopt measures to implement the laws that TISA allows you to do. But you can't, this is not a defense for laws to implement fraud or privacy laws that might be inconsistent with TISA. For example, that might be discriminatory, yeah? Or that might be requiring a local presence, or might require the data to be held in the country. Yeah? So it's only basically allowing you to do what you're allowed to do anyway. Yeah?
So, yeah, I mean, is it like the credentials self-count?
It gets worse. It gets worse.
Okay, hold on.
I'm going to show it to you again in a moment. Yeah. So, but this is why it took us a while to actually realise that when it was in a general exception, it is a bit like the prudential second sentence that says you can do what the agreement allows you to do, or you can't use the defence as an excuse for breaching the rules. And why would you need a defence if you hadn't breached the rules? Because you'd just be doing what you were allowed to do anyway. But in addition to you being allowed to do what you can do anyway, it says the way that you do what you're allowed to do anyway must satisfy a necessity test of being the least burdensome way of doing what you're allowed to do anyway. Okay, now I'm going to show you the actual text and then we can come back and do it again. This is, I know in the EU that this is really important, so I do want to make sure that you get it. And I have to say that I hadn't paid any attention to this until about 9 months ago when I realised. And I have then been taking negotiators in various, because this is rolled over in all agreements, including all the ones where the e-commerce texts are now coming up, including the TPPA. And no one has actually looked at the fact that this is a total nonsense. And I need to go back into the negotiating history as well and see it.
Question, does anybody know whether there is an e-commerce chapter in the EU-Japan agreement?
Oh, there will be. Japan has it.
And whether to the extent that we have it in CETA or whether it does go beyond, because for the EU-Japan...
E-commerce is much weaker in CETA.
Yeah, but for the EU-Japan...
Japan is a big advocate. It's the main advocate in the RCEP of the e-commerce text.
Japan teaser was the e-commerce is similar to the one that you have in Japan at the moment.
Okay, we're going to look at this general exception again on Friday in relation to health, environment and so on. And some of you may already be familiar with it in that context. And of course, okay, so we're on page 12 of the core text. And we are Article 1.9, General Exceptions, and we're scrolling down to paragraph C. Now, don't look at the first bit yet, the necessary. Ignore the necessary for now. Yeah? We'll come back to necessary. Okay? Nothing in this agreement shall be construed to prevent the adoption or enforcement by any party of measures to secure compliance with laws or regulations relating to the prevention or deceptive fraudulent practices, or to deal with effects of defaults on services contracts, very narrow consumer protections.
That's the consumer
Yep.
protection thing.
Yep. Or to secure compliance with laws or regulations relating to the protection of the privacy of individuals in relation to processing and dissemination of personal data. So not storage, access, sale.
Authorities kind of processing storage is also kind of...
No, they distinguish between processing and storage. And protecting the confidentiality of individual records and accounts. So we have got nothing shall be construed to prevent adopting or enforcing measures to secure compliance with laws and regulations, including those relating to deceptive, fraudulent practices of privacy of individuals for those things. Now, That is, I think, as far as most negotiators and so on look. Yeah? But let's just start adding some new words in. Nothing shall be construed to prevent adoption or enforcement of any measures to secure compliance with laws or regulations which are not inconsistent with the provisions of the agreement. So if they are discriminatory, or if they are requiring a local computer facilities use or local storage of data or whatever that is a breach of the rules, then this is not going to protect you because it's not a measure to secure compliance with laws and regulations that are not inconsistent with the agreement. You're trying to secure compliance with laws and regulations that are inconsistent with the agreement. And then you have, in addition to that, so that's basically saying you can't do it for ones that the agreement doesn't let you do, but you can do it for the ones the agreement does let you do. Right? So nothing shall be construed to prevent the adoption or enforcement of any measures to secure compliance with laws or regulations which TISA allows you to have, right, in relation to those two things. But it has to be measures that are necessary to secure compliance. So it can't be the most draconian version of the ways of implementing those laws. The necessity test is that it has to be the least burdensome of the available ways of implementing those laws. Yeah? So it's not just that you can implement the laws you're allowed to implement, but when you do that, your choice has to be the least burdensome, the least intrusive of the options available to do what you're already allowed to do. So it is not an exception. It is an additional restriction on what the agreement lets you do. I will explain it again. Yeah? So what we have got is the agreement shall allow you to adopt measures to secure compliance with laws that are consistent with TISA. Huh? But it will only allow you to do so. It will not prevent the adoption, or not be construed to prevent the adoption or enforcement of measures to implement laws that are consistent with TISA, provided the measures are necessary to secure those laws. So it means if the word necessary wasn't there, it simply says you're allowed to do what you're allowed to do. By putting the word necessary in there, they're actually conditioning further what you're allowed to do by saying, when you do what you're allowed to do, your choice has to be the least restrictive option to do that. Okay? So it's not an exception. It's actually an additional restraint or restriction on the way that you're allowed to implement the laws that you're allowed to implement. Yeah?
Can't you just say you're not allowed to do anything unless...
Right. And this is, I mean, when I say that we just discovered this, and when we point it out to negotiators, they go, that can't be right.
Yeah, I mean, this was it just...
Well, I need to go back to the drafting, but see, this is, the privacy stuff and so on isn't in the GATT.
But it's in GATS?
It's in GATS.
Just like...
This is the general exception from GATS.
But nobody ever...
No one's looked at it because privacy's not been an issue.
But it is so weird because it's not parallel to the other.
No.
I mean, because...
Yeah. And then, not only do you have that restriction, that it must be the most light-handed and so on, but we have up here what we call the chapeau, which means that it must not be applied in a way that will constitute arbitrary or unjustifiable discrimination between countries with like conditions. So we can't be treating, Switzerland can't be treating its domestic in applying the privacy laws it's allowed to apply under TISA in a way that is arbitrary or unjustifiably discriminatory against another country. So not only do you have to make sure that your laws, privacy laws, are consistent with TISA, and your operational rules for implementing those privacy laws are the least burdensome of the ways you could do it, but you need to make sure that also they don't involve arbitrary or unjustified discrimination against another country's services and service suppliers, or a disguised restriction that is benefiting your industry or your suppliers against those of another country. Yeah? So this is not a protection for privacy. This is a multi-layered, complex set of rules that make privacy laws extremely constrained. Constrained by the rules of TISA, constrained by a necessity test, and constrained by what we call the chapeau, that bit up the top.
The necessity test then be done if one party accuses another one and they go to
A dispute,
yeah.
yeah. If there is a dispute, there are different shifting burdens of proof as who has to show what in the defence, yeah? And the definition, and because this is multi-layered, I'm not actually sure who would end up having to prove what, because there's more layers than in the normal one. But necessary, usually it is the complaining country that would say there are other ways that you could have achieved this that were reasonably available to you that you didn't take. Yeah? So it's not that every fantasy possible thing you could dream up, you know, they needed to have considered and why they didn't do that. It's what was reasonably available, and if there is a reasonably available, less burdensome